the division bench has said, special bench has not answered the second question.
Show it.
I'll show you, Lordship. But first, my lord, I would like to, my lord, address your lordship, subject to your lordship's permission, because there are judgment both ways. Whether filing of an appeal by itself would be a situation where the court should restrain itself from proceeding or not. There is no clear-cut case that no, it cannot. But my lord, there is one judgment of 2002 which says that the court should be slow in progressing. Why? I mean the contempt court. Why? Because the order has not yet reached finality. Your lordship may kindly may not have a take to
Because,
look at.
now that is what the question I would like to put
Yes.
to you. If you can bring a stay order from the Honorable Supreme
Yes,
Court,
yes, yes.
then everything will over. Of course, your objection as to the jurisdiction of this court to hear out the application would be decided. And if he wants to proceed with that risk, let him proceed, because in this way, piecemeal way to be decided, one issue, one appeal, another issue, another appeal, main thing will go. So just tell me what is the position of your Supreme Court.
My lord,
I have got the information. The position is there are so many mistakes. The defects says you have to refile. Refile. It's not just cure. I have taken a print of that. Refile entire petition.
my lord, my instructions are, my lord, defect has been cured on 5th.
Mr. Dotto, just tell me a specific date, because I am
Very difficult, but I cannot
Then-
have
then-
control of
then-
my lord, the
then
Supreme
by,
Court.
by
affairs.
we have
And we come and mention before your lordship, my lord.
Mm.
We are completely at the mercy of the court when to fix a matter,
No.
whether at all to fix a
No.
matter.
pendency, you know that pendency cannot I say that for the pendency, particularly in view of the nature of the order I have passed with a specific direct to be given immediate effect. Therefore, you have filed a SLP, the contempt will be deferred. Don't think it will be a proper justification. It will be a justice to the petitioner who has approached this court. So tell me, can you give me a reasonable time that within which time you can get it without laboring yourself with this?
But I have requested them to mention it today before the Supreme Court. My lord, I do not know what is the situation over there. But as I gather, my lord, from people, my lord, that my lord,
No,
very frequently, my lord, the Supreme Court systems change. Now, my lord, I'm told, my lord, with the new Chief Justice, my
of
lord,
course,
and
it is a
yes.
new for you. All new judges and
Yes.
new rules come.
But may we come back, my lord, on next Monday, my lord? Let us see, my lord, whether, my lord, we can make a mention in
Well,
the
I
meeting.
shall be praying that Lordship kindly issue the reason is
No,
this.
he is appearing. I'll be asking some questions. If I'm not satisfied, then I will ask for it.
Because
Of
effectively,
course, I will issue.
what I'm saying is I could have understood. there is no prayer
But
for
in that
was
case,
there.
sir, may I proceed with my objection that it should be before the division bench? If my learned
No,
friend can
no,
wait
Mr.
for
Dhar,
a week,
Mr. Dhar, it will. I don't think that that he is taking a plea. Of course, if he succeeds. If he fails, then of course there will be an appeal. The same way.
My lord, already twice, my lord, I have faced it. Twice I have faced it, and twice ultimately the your lordships and twice I'm saying, starting from the maintainability, every time,
From that experience, I am telling you, in peaceful appeal,
my lord, there is no,
objection
I say,
he
there
has
is
taken.
the objection. The learned advocate general is relying on the Boishaki judgment of the division bench. That is, my lord, 26,000 teachers case. In that judgment, the High Court and the Supreme Court's order
Differs. That I
was
understand.
modified. So therefore, referring, I don't understand how that would be, well, at all relevant.
very well, let me start.
Mr. Dotto,
Let me start.
Mr.
My lord, no use, my lord, my lord,
That is a-
yes,
uh,
making submissions without the judgments. Let us start with the judgments. Let us start with
I
the
am
judgments.
concerned about my time.
Yes,
You may say that you have, of course, both of you are here for that purpose.
Everybody is here.
everybody is here for somebody else's cause.
Everybody is here to somebody else's cause. Eh? Mr. Dhar,
Yes.
I should suggest I should give at least 2-3 days to
2-3
Mr.
days, no difficulty.
Thursday.
Give me a week, my
But
lord. I'll
the
tell you,
last
Lakshmi,
days,
give me a week, my lord.
I am not saying that at least your pressure may compel your
Lord, I
not
have, my lord, tried to
compel
put,
them at
my lord,
least to
as much pressure possible
no,
from my
at
side.
least to rectify the defects.
No, I'm told me it has been rectified, subject to correction.
At
My
least to
immediate instruction
rectify,
is it has been rectified.
at least to rectify the defects. At least you can apprise definitely to this home.
My lord, in fact, my lord, a letter has also been issued to the registrar of the Supreme Court, with my lord, apprising him of, my lord, whatever has happened, my lord, in this proceeding, so that, my lord, the matter can be, my lord, urgently listed.
Thursday.
आगे कौन सा तारीख? 8th. We have asked for listing on 8th, that is today. It has not been listed.
Thursday. এটা Thursday time fix করে রাখো তো।
ঠিক আছে।
Thursday time fix
এর
করে
মধ্যে
রাখো।
কিছু একটা কর। But Mondays and Fridays are the miscellaneous days.
Please
Oh.
post yourself with all, not this way. Before you approach, get yourself satisfied. Yes, you can say something on it.
Very.
না Thursday করে রাখো, order করাটা।
This is the Supreme Court site where from defects cure or not, that can be seen. Still, the defect is
Mr.
refined in
Dhar,
that
Mr.
petition.
Dhar, it is the Advocate General
That's I
submitting.
take it.
It is not than A, B, C, D submitting.
I take it, but
I am giving that much credence, I should. It is the Advocate General is saying, not Kishore Datta himself, an advocate is saying. I must give credence to it.
Very.
This is
Fine,
for
careful.
learned Advocate General also, that because it has to come from the AOR from the Supreme Court, that in Supreme Court the moment it is cured, just like the server, it is shown just for consumption of the learned Advocate General.
No, if that person, that advocate makes the Advocate General mislead the Advocate General, he is to
Only for
take,
that purpose.
he will take care of it. I think so. His submissions has somewhat weight. Heavy weight. Which I cannot lift in the morning.
Well,
I'm trying, but I cannot.
in the meantime, the copy, because otherwise what will happen that they
Copy
might
means?
the copy
It's Fab, he is
Yes.
appearing, arguing. What
they are
happened?
not interested to text, so that's the reason.
Can I record your presence?
Yes, definitely.
Mr. Kishore Datta, learned Advocate General, appears on behalf of
Copy is
the
handed over.
alleged contemners. Copy of the application be
Handed over to
contempt
the-
application be served upon the advocate on record.
No, the
Please note
acceptance is subject to, my lord, the jurisdictional issue that I have raised.
Huh?
This acceptance is subject to the jurisdictional issue that I have raised.
What is mean? You have appeared, I have directed to serve. Are you conceding to the jurisdiction?
No,
Does
no,
it
no.
mean so?
But it may be said
Maybe,
subsequently, my lord.
It is merely you are appearing, otherwise you don't appear, I will direct formally to
Yeah.
service. There is one thing. When you are preempting the notice, I am just said serve upon the advocate on
Very.
record.
I'm grateful. Thursday.
Thursday.
My lord, in this matter, I am put a state, my lord, on the last